Imagine coming back to the house you've shared with your partner for a decade, only to realize that because they died, you might not legally be allowed to stay. People often assume that living together for a long time creates a common law marriage. The truth is, that concept does not exist in English and Welsh law. 10 years of shared groceries and mortgage payments grants you exactly zero automatic property rights if your partner dies. Instead, your situation falls under intestacy. This is the rigid, state-mandated rulebook that takes over distributing assets when someone dies without a valid will. Let's map relationship options. The horizontal axis tracks effort. The vertical measures protection. Bottom left is cohabitation. Zero effort, but zero automatic protection. Top right are marriage and civil partnerships. They require high effort, but legally protect your assets. The legal system ignores emotional commitment. It only recognizes strict bureaucratic compliance. You have to trade paperwork for financial survival. So how do you get into that highly protected top right quadrant? You have to clear specific legal hurdles, starting with what the law calls capacity. Capacity represents the absolute legal minimums. In England and Wales, both of you must be at least 18 years old, not closely related, and not currently married to someone else. If you ignore or fake your way past these rules, the state stamps your relationship void. A void marriage means the court treats your union as if it never existed, from day one. You were never legally together. Discovering a union is void retroactively strips away all expected intestacy rights. If your partner dies, you are treated as a complete legal stranger. Assuming you meet the legal requirements without actually verifying them is a massive gamble. You risk erasing a lifetime of assumed financial protection. If you have capacity, you then face formalities. These are the exact procedural hoops you have to jump through, starting with giving 28 full days formal notice of your intention at a registry office. Then there's the venue. A civil ceremony must take place in an approved premise licensed by the local authority. Skip this, and the court declares a non-marriage, a ceremony so legally deficient it doesn't even qualify to be voided. To see how rigid these rules are, look at Prince Charles. When he planned to marry Camilla Parker Bowles in 2005, they intended to hold the civil ceremony here at Windsor Castle itself, but they discovered too late that the royal residence did not actually hold a legal license for civil weddings. Even the heir to the throne wasn't exempt from the state's formalities. They had to relocate the ceremony at the last minute to the licensed Windsor Guildhall just down the street. Religious ceremonies have their own specific rules. Jewish and Quaker weddings are legally valid if they follow their distinct traditional usages, provided they first complete the required civil preliminaries. Meanwhile, a Church of England wedding skips the civil registry notice entirely in favor of the publication of banns, a public announcement in the parish church. Whether you are royalty or a civilian, having a religious ceremony or a secular one, failing to strictly adhere to the state's procedural formalities leaves you legally unprotected. Let's put these three relationship statuses in a comparison matrix to see the functional differences. Here is one major vulnerability unique to heterosexual marriage. It is voidable, meaning it can be annulled if the marriage is not consummated. Civil partnerships bypass this physical requirement entirely. But the ultimate stress test for these statuses is the intestacy payout when a partner dying. For marriage and civil partnerships, the surviving partner automatically inherits the first £322,000, all personal chattels, and half of whatever remains. For cohabitation, the automatic payout is absolutely zero. If an unmarried cohabitant wants to keep their shared home, they have to hire lawyers and fight in court under the 1975 Act. It's an expensive and highly uncertain battle. Completing the bureaucratic hurdles of a valid union guarantees an automatic state-enforced wealth transfer. Cohabitation guarantees nothing but legal vulnerability. You have to make an active choice about your legal status. This decision tree starts with a simple question. Do you want automatic financial protection? If yes, and you value historical and religious frameworks, choose marriage. Just ensure your celebrant properly executes the legal formalities. If you want the exact same gold standard property protections without the patriarchal baggage, choose a civil partnership. But if your answer is no, if you absolutely refuse to form a state-recognized union, you must actively opt in to protection by drafting a legal will. A will is the only safety net for those who remain in that bottom left quadrant of low effort and low protection. The legal system cannot measure how much you loved each other. The law only cares whether you filed the correct paperwork to prove your relationship. Choose your legal armor before it's too late.